May it please the court. Good morning.
Good morning, Mr. Booth. Just hold on one second. There we go. It looks like opposing counsel just got in there. So we're set. You may proceed.
May it please the court, counsel, good morning. My name is Rainey Booth Jr. I represent the appellants. May I please reserve 5 minutes for rebuttal?
Very good. I'll let you know when you get to that point.
Thank you. The sole question in this appeal is whether Mr. Castillo signed the admission agreement in his capacity as Rosa Castillo's power of attorney. The clear answer is no. Based on the plain language of the agreement, Mr. Castillo did not sign as her power of attorney, but instead in his capacity as her healthcare surrogate. Therefore, the arbitration agreement is not enforceable and the order on appeal must be reversed. The standard of review of the trial court's construction of the agreement, as well as its application of the law to the facts, is de novo. The task before the court is construction of the admission agreement. The admission agreement is a contract like any other. It must be construed like all contracts.
Mr.
Courts
Booth,
are confined.
Mr. Booth, I have a question. The contract itself provided pre-printed initials for HCS, Healthcare Surrogate, next to Mr. Burleson Castillo's name. So it wasn't a choice that he made necessarily, but given that that language was put there, shouldn't that be construed against the nursing home?
Exactly, Your Honor. It is axiomatic that the drafters of contracts, any issues, ambiguities are construed against the drafters. And the trial court found, as a matter of fact, at page 41 of the appendix, lines 9 through 10, that the appellees drafted those designations of healthcare surrogate. It is uncontested that HCS means.
So he didn't make the choice himself, right?
Respectfully, Your Honor, I do disagree. At the time of signing, those designations had already been added to the contract. He signed right next to those designations. He knew what they meant. And he didn't.
Unlike the Etheridge Palm Garden case, where there was a choice that the healthcare surrogate or power of attorney could make, Mr. Burleson Castillo didn't have that choice here, did he? I mean, it was already on the form. It was already printed on the form.
Correct,
It wasn't
Your
a
Honor.
decision for him to make.
Correct, Your Honor. It was already on the form, but when he signed next to it, he knew what it meant and he didn't cross it out. He didn't write POA. He didn't add POA. He didn't change it whatsoever. It was there, like you said, and they added it. The appellees added it. It wasn't form boilerplate language like most of the remainder of the contract. It was added at a time when they knew he was both power of attorney and healthcare surrogate. They knew that those two different capacities were chalk and cheese. They did not mix. They were separate and distinct. And they still added those designations. Those designations are clear, they are unambiguous, and they must be construed against the drafter. The same goes, Your Honor, for the X mark that the appellees are relying upon to indicate his agreement to Section O, which is right above on page 91 of the record. That is an X mark that was added prior to him signing. The appellees do not want you to ignore that X mark. They do not want you to treat that X mark as irrelevant. They do want you to ignore the other information they added, the specific designation of healthcare surrogate. But again, the plain language of the contract controls, as this court stated in Paddock, where the language of a contract is clear and unambiguous, the court can give it no meaning other than that expressed. In that case,
Mr. Booth, let me ask you this. We have to look, I know you're directing us to the terms of the contract here. The preliminary statement states that the resident includes anyone with the legal authority to act on the resident's behalf. And so I appreciate what you're saying with the HCS designation, but we have Mr. Burleson Castillo here who read, the laws presumes that you read the contract The checkbox, as far as the dispute resolution procedure is checked. He also signs under the legal representative for the resident. He has previously provided to them his durable power of attorney. And, you know, I think this is the distinction between the Etheridge case, because in that case, while the daughter had the durable power of attorney, she signed not under the legal representation, but she signed as a responsible party, which are facts that we don't have. Then we have, you know, the further signatures of the acknowledgement. And so it seems to me that all the boxes are checked here in this case, that Mr. Burleson Castillo signed as the legal representative with the authority to bind the estate to the arbitration dispute resolution.
Respectfully, Your Honor, I disagree. I agree that he signed as a legal representative. Healthcare surrogate is a type of legal representative. The face of that document shows it is a legal document. It says, be careful, this is a legal document. It actually says this supersedes all prior durable powers of attorney that deal with healthcare. That is a type of legal representative. But
you don't, okay, and I understand that. There's no dispute here, though, that the power of attorney was also provided to the to Heather Hills, I think it is.
That's exactly correct, Your Honor. That was the other point I was about to make. That's exactly correct. Not only did they have the power of attorney, they had the healthcare surrogate. They were both provided at the same time. And the appellees, they were the more sophisticated party in this bargain. They had more bargaining power. They knew what healthcare surrogate meant, and they knew what power of attorney meant. They do this every day. And they drafted the contract, and they drafted the designations. And as Your Honor, Judge Morris stated, those must be construed against them. They cannot be ignored. They cannot be treated as irrelevant. As this court stated in Paddock, all provisions of a contract must be so construed as to give effect to each. So not only must they be construed against the drafters, the appellees, they cannot just be rendered meaningless if there's a way to interpret them that gives them meaning. And to ignore them or to treat them as irrelevant would render them meaningless. And remember, as I've said multiple times, the appellees are the ones who added those designations to the contract. Etheridge, since we brought up the Etheridge decision, Etheridge teaches us that signing while power of attorney is not enough. You have to sign as power of attorney. Moreover, it is very clear, well-established law, that it was the appellee's burden to establish that he signed as power of attorney. It was their burden. We cited numerous cases, one of which is this court's decision in Davis. In Davis, this court stated to enforce the arbitration agreement, the nursing home had to show, one, that there is a valid written agreement to arbitrate. And that makes sense. The right to a jury trial is a fundamental constitutional right. Powers of attorney are strictly construed under Florida law. Appellees try and distinguish Davis. They say it doesn't apply. That's not what the case stands for. The court in Davis went on to say the issue raised in this appeal is whether the nursing home met its burden to show the first requirement, the existence of a valid written agreement. So it is not enough that he had a power of attorney, but signed his healthcare surrogate. That's what Etheridge teaches us. That's what Lepisto teaches us. Both those cases actually say that the express designation of one capacity excludes the others. And that is
let me ask one question about that part of your argument. The document itself does not indicate that he is signing as power of attorney or as healthcare surrogate. It simply lists the relationship as healthcare surrogate. Does that pose a problem for your argument?
No, Your Honor, it does not. The relationship line is there to indicate the specific type of legal representative for this exact situation. When there are folks who have more than one legal representative capacity that they could be signing in, or multiple that they could be signing in. If that is unclear, page 92 of the appendix, the final page of the center admission agreement, has a signature line that makes this abundantly clear. The signature line there for the resident or the representative under the line says resident / legal representative. And immediately after that In a parenthetical, it says indicate relationship. It demands that you indicate the relationship of what? The specific legal representative relationship. So it is clear from the contract as a whole, staying within the four corners, that that designation of healthcare surrogate is meant to specifically define the type of legal relationship that is being used to sign the contract. That designation is included unambiguously throughout the agreement. Every time it is included, it is immediately adjacent to Mr. Castillo's signatures.
Let me
It
ask
is-
you a related question. Does the law require that a person who has a power of attorney execute a document indicating specifically, John Smith as power of attorney or as holder of power of attorney?
That is a question that I wish I had researched more, Your Honor. I was taught in law school that that is the proper way to sign when you're signing as a power of attorney, that you sign on behalf of a person as power of attorney. Of course, the rule that the contract as construed against the drafter would fill in here if the court thought there was anything ambiguous about the designations or about the way he signed, and it would have to be construed against the appellees. But Florida law definitely holds that when you sign in one capacity, that excludes the others. That was the holding in Etheridge. Respectfully, the daughter in Etheridge signed as responsible party only. And this court concluded that that designation of responsible party only excluded her capacity as power of attorney. She did not sign as responsible party and not as power of attorney. She also didn't sign as power of attorney.
Mr. Booth, do we know the specific facts in Etheridge, whether there was, how the signature block was? Because when you're saying she signed as responsible, are you saying that she actually signed her signature and then put comma as responsible party? Or was it a very similar, block like what we have here, which is legal representative?
It was similar to the block. In fact, it was more similar to the relationship that's designated throughout Healthcare Surrogate. It was immediately adjacent to the line. The block for legal representative is much farther above within the layout of the contract. The actual legal relationship defined, Healthcare Surrogate, is immediately adjacent. The responsible party designation in Etheridge was immediately adjacent to the signature, and it was the only capacity included. Just like here, the only capacity designated in the entire contract is healthcare surrogate. There is no statement whatsoever that he was signing as power of attorney, and there's no term that even creates that impression. The legal representative term, we've discussed that. The acknowledgement is similarly a red herring. That acknowledgement only says two things: that he's authorized to sign for Rosa Castillo, he was, and that he agreed to accept certain duties and responsibilities. He did. That acknowledgement does not say he signed as power of attorney. It doesn't even suggest he signed in multiple capacities. It is entirely consistent with him signing as healthcare surrogate. Jackie Bott testified that healthcare surrogates were allowed to sign the admission agreements on behalf of residents. That's for a similar reason. The appellee's reliance on the testimony about the separate procedure that was in place is also not helpful for their argument. It does not prove he signed as power of attorney. The testimony about that procedure was simply this: the social worker would check and make sure that the representative had the ability to sign the admission agreement prior to sending the paperwork. That testimony is not specific to the arbitration provision. It's not even specific to section O within the agreement. It talks about the entire agreement. And Jackie Bott testified that healthcare surrogates were allowed to sign the admissions agreement. That's at page 238 in the appendix, lines 14 through 19. So all that proves is that even if Mr. Castillo was never Rosa Castillo's power of attorney, he still would have received the paperwork under that procedure. It certainly doesn't prove that he signed his power of attorney. Again, the burden was on the appellees to establish he signed his power of attorney. There was no presumption in favor of arbitration yet. It goes without saying that we are here this morning because the appellants contest ever agreeing to arbitration. This court
Mr.
stated—
Booth, you're at your 5-minute mark. I just wanted to let you know.
Thank you, Your Honor. May I just finish and then I'll wrap
Yes.
up? Thank you. This court stated in its decision, UATP Management LLC versus Barnes, that there is no presumption in favor of arbitration. if the parties dispute ever agreeing to arbitrate. So it was the appellee's burden, with the help of no presumptions tipping the scale in their favor, to establish that Mr. Castillo signed in his capacity as power of attorney. They failed to do so. There is absolutely no evidence that he did. In light of the unambiguous language of the contract, the trial court had no option other than to enforce it as written and deny arbitration. Thank you.
Thank you very much. Mr. Smula.
Good morning, Your Honors. May it please the court, Brandon Shamula on behalf of the appellees. The issue on appeal here, it centers around choice. Whether Mr. Burleson Castillo made the choice at the time of signing the arbitration agreement to sign in his capacity.
He really didn't. He really didn't make the choice. It was a pre-printed form. He just signed like any lay person would. They wouldn't really drill down on what that was. The nursing home made the choice.
And so I think that gets directly to the heart of my argument, Your Honor. It begs the question, why? Why would someone with no legal background, who provided a power of attorney ahead of time, acknowledge that he had authority to make decisions on behalf of this particular resident, intentionally choose to sign an optional and voluntary agreement? I think the biggest point that's being missed is that this arbitration agreement, it's optional. Why would this individual choose?
But isn't the protocol of your client to get copies of power of attorneys and healthcare surrogates? Don't they say if you have these things, we'd like copies of them? Wasn't he just doing what he's asked to do?
Well, absolutely. What Jackie Bopp, the admissions director, what she testified at deposition to, was that the director of social services, she had the responsibility of verifying the authority of the individual before they would even ever provide documentation to the resident.
Well, again, there's two types of authority here. One is as attorney in fact through a power of attorney. The other is to make critical healthcare decisions when the patient can't make them for themselves. So those documents each represent authority. They just represent a division of authority.
Correct. And with the admission agreement that was signed by Mr. Burleson Castillo, the authority under both of those was definitely utilized. There's medical decisions that need to be made.
Where does the document indicate that they were both utilized?
The document being the admission agreement?
The document that presumably your client prepared and inserted the initials HCS.
Well, the document was signed, so there's different portions of the document. There's portions.
Okay, well, let me ask a simpler question. Is there anywhere in the document a reference to a durable power of attorney?
Meaning, is there a specific section within the document signature?
Is there anything in the document that refers to a durable power of attorney?
Those specific words, no. However,
is there anything in the document indicating that he signed in his capacity as the holder of a durable power of attorney?
So the document itself, no, but in totality within the evidence that was reviewed by the trial court, yes.
Well,
in this document,
explain that to me, because we know as a matter of law that a person can sign in various capacities. Head of a corporation can be signing a guarantee as an individual. He can be signing, and this has happened, as guarantor on behalf of the corporation, which the case law says is meaningless because the corporation's already on the hook and the individual is not individually bound by a guarantee signed in that capacity. So how is this different when the only indication on the document itself is that the relationship he is asserting, or your client asked him to assert, is the holder of a healthcare surrogate?
So what the trial court looked at, in addition to the agreement itself, was the testimony of Jackie Bopp, as well as the testimony of Mr. Burleson Castillo.
And Ms. Bopp was not a party to the signing, or was not present at the signing, correct?
She signed, the document was signed based on the evidence using DocuSign, so an e-sign. She did sign the document on behalf of the facility.
So she did not engage with him. Well, let me put it this way. There's no evidence of her engaging with him, correct?
Her testimony was that she didn't recall that specific signing, but
okay, so there's no evidence that she engaged with him, right? I mean, I think you're saying, yes, that's correct.
Other than her signature on the actual document. So if by engaging with her, do you mean a formal sit down at that time? No, I don't believe so due to the COVID restrictions.
And there
But in
was no,
DocuSign, you don't really engage with each other. I mean, we've all signed DocuSign things before. There's no give and take. The document is signed by one person and it's electronically transmitted to the other person who signs. There's no real sitting over a table talking about it.
And I think that's why the procedure is so important here in this case and why it's distinguishable from Etheridge, because they did have that procedure in place in where they verified authority to sign by receiving the durable power of attorney. And I think the testimony of Mr. Burleson is also very important. And I want to just read to you, Your Honors, a very short portion of his deposition testimony. The question asked, did you tell them you had authority to make decisions on her behalf? Answer, yes. I also gave them copies of the documents that I had from my attorney. Question, which documents were those? Answer, healthcare services. I don't know what else I gave them. I do know that it was the durable power of attorney. Question, so based on the paperwork that you provided to them, they then emailed you with her admission forms. Is that right? Yes, and that's page 37, lines 4 through 14 of his deposition. And so he's acknowledging that he has...
Each of those documents represent different types of authority, correct?
Correct.
And they are both sufficient to constitute legal representation on behalf of the resident. One, to make healthcare decisions, get copies of documents, healthcare records, and so forth. The other, a durable power of attorney that deals with finances and signing contracts and so forth. So you have two different types of authority, correct?
That's correct.
And this document that your client apparently prepared could have indicated that the power being asserted by Mr. Burleson Castillo was under the durable power of attorney or the healthcare surrogate or both, right?
That's fair.
Okay.
And if I can just clarify on that, I think, and forgive me, Your Honors, on who pointed this out, but there's no real indication within the arbitration agreement that says, it says legal representative. And then there's a separate line that says relationship to resident. There's another portion of this document, this admission agreement, in which he puts spouse. So it's not clear. It's not as clear as Etheridge. And this is one of the distinctions that we have, where in Etheridge, I actually reviewed the arbitration agreement. And within that provision, there were two separate boxes. One box for responsible party and one for signing as durable power of attorney. Also, at the end of the document, there was one for legal representative and responsible party. In that case,
there are distinctions with Etheridge. However, what I'm concerned about is your client accepted a document and apparently prepared a document that represented his capacity as being under the healthcare surrogate form. So as Judge Morris pointed out, he may not have made an election as to what capacity he was signing in, but it appears your client did and accepted the form as under the healthcare surrogate authority that he had.
Now, my response to that, Your Honor, respectfully, would be that the trial court looked at all of the evidence, including the procedure in place. And that is
there was no evidence presented. Mr. Burleson didn't say, oh, yes, I meant to sign as durable power of attorney. He said, I signed what they gave me. And yes, I gave them copies of documents. He might have also given them a copy of a DNR. He might have given that. I mean, who knows what other documents he gave. He said he gave them the documents they asked for. But that doesn't mean he is signing under the authority of a given document that isn't reflected on this agreement, does it?
Well, again, that gets to my initial point, Your Honor, of why would somebody choose to do that? Why would they choose to be healthcare surrogate knowing that that's not an authority they have when already acknowledging they have the authority for those decisions and providing the documents that support that authority? And I think,
I guess my question is why then should your client not have this document construed against him as the drafter, which is about the most well-settled law there is in contracts? The document is construed against the drafter. Why shouldn't that be done in this case?
Because, Your Honors, we have to look at the totality of the evidence and how the trial court weighed that evidence. And so by, again, looking at all of the testimony, looking at all of the documents, looking at the contract itself, which admittedly is not clear. It doesn't have one line that says legal representative HCS. It's a separate portion that says relationship. And so
there is no indication of any capacity that he is signing in. Is that what you're telling us?
Well, there is section P of the agreement that it's titled acknowledgement of legal representative. And what that says.
And that doesn't mean much of anything unless it is a durable power of attorney that is being utilized to assert legal representation, right?
That's fair.
I mean, I can have a durable power of attorney for my wife, and I can sign a bunch of things for her. But if I don't indicate that I'm signing as durable power of attorney, is that valid to bind her?
Well, there are a number of cases, and forgive me for not having them on me as far as apparent authority concerns. We go through that all the time in these arbitration issues where individuals don't even have a power of attorney and they still uphold the arbitration agreement based on apparent authority. In this case, and I'm not arguing that in this case because he actually did have authority under the document. I mean, this may be as simple as a typo in the document, and I'm not saying that's what it is, but it's clear based on all of the evidence and the testimony, the procedure that's in place, and how it's structured there as legal representative, that he did in fact have the authority, and that's the reason he received the paperwork in the first place.
That same argument, I guess, could be said in Etheridge, and the daughter there had the legal authority, but they didn't impose that legal authority on her in Etheridge. They only allowed her to escape with the responsible party.
And the distinction, I think, with Etheridge and what this court obviously is well aware of, being that decision came from the second DCA, is that it came down to and boiled down to a choice. And she made the choice to sign as responsible party. And with that agreement, we were given the benefit of a definition of responsible party versus legal representative. And she made that choice.
The same can be said here, that he made the choice to only sign as the HCS, and he signed it, knowing he also had a durable power of attorney.
Well, Your Honors, respectfully, I would lean on the entirety of the evidence that was reviewed by the trial court. The trial court was well versed in all of the submissions, the oral argument, and they applied the evidence and the facts to the law and came to the conclusion that this was a valid and enforceable agreement. And they came to the conclusion that he was using his capacity as a durable power of attorney, and mostly pointed to the fact that they had that procedure in place. There was a procedure in place. They had the appropriate documentation. Unfortunately, in this particular time, we were dealing with COVID and they couldn't be in front of him because these facilities had protocol. And so they e-filed or emailed the documents to him. He signed them. They were provided to him based on that authority that he had. He never would have received that power, or excuse me, that arbitration agreement had he not provided the durable power of attorney and advised them of his authority to make those decisions. And so it's our position.
Let me just ask you this. I know before you conclude, was there any evidence that in this relationship box that they ever put POA?
Are you referring to the arbitration agreement or the admission agreement in this case?
Any of them. I mean, we have several lines where the legal representative signs.
It does not say
evidence.
It does not say POA in the. There are some that just says legal representative, but it does not specifically say DPOA.
Okay, I guess my question is was there any testimony from the facility that in that relationship box that they ever put POA?
No, there was no testimony that the facility representative who signed that she specifically wrote that in there. No, she talked more about the standard practice and procedure of the facility for presenting the admission paperwork to residents.
I think I'd like you to clarify for me, or maybe address under Etheridge, because you've said a couple of times that Etheridge turns on the option to sign in one capacity versus another and so forth. But I think that's part of the factual background of Etheridge. It seems to me the holding of Etheridge is, at the very end of it, it says, because Smart signed the admission agreement as the responsible party for Taylor and not in her capacity as Taylor's attorney in fact, She did not have the authority to consent to the arbitration agreement. We must therefore reverse. And that's the holding. And so it doesn't, again, I understand the factual background leading to the holding, but the actual holding is limited to she didn't sign in the capacity as the holder of the durable power of attorney. Isn't that what we have here?
Well, it's slightly different. Again, because in that case, we had the benefit of a definition of legal representative, which
But you've already acknowledged that the legal representative definition, which actually is not defined in the contract, applies to both legal representative for healthcare purposes and legal representative for those purposes contemplated by the durable power of attorney. So there are multiple legal representative capacities.
and that's fair. But as I mentioned before, the legal representative in our case, how it's different again, I would go back to Section P of the agreement, which talks about the authority to make these specific decisions on behalf of the resident. And so that's what we would lean on as far as the document itself. We don't have the benefit of a definition of legal representative.
Doesn't that fly contrary to Etheridge, where the individual also had a durable power of attorney? And that's not the only case. There are other cases that are similar, where a person has a durable power of attorney, but they didn't sign in that capacity. I mean, it seems to me that's a problem that your client has created for itself by not insisting that the document be signed in the capacity as holder of the durable power of attorney. And it's something, honestly, I don't understand why these cases keep coming up, because it's an easy fix. You know, the document should say what the nursing home or the hospital or rehabilitation center requires to make it a binding contract. It's an easy fix, and I don't quite get it, other than the fact that it's not lawyers who are at the signing of the document.
That's a fair point, Your Honor. It's something we do deal with from time to time. Obviously, you see these cases a lot as well. You know, again, I know I've repeated myself quite a bit here, but I'm relying on the totality of the evidence, not simply just what that one line, that pre-printed HCS says. The interpretation that we have of Etheridge is that there was a choice made not to sign as the power of attorney. There were two options, and they chose. And what the trial court looked at was that there was, in fact, no choice by Mr. Burleson Castillo. He never chose at the time to sign as healthcare surrogate. He signed the legal representative.
And he also never chose to sign as the holder of the durable power of attorney based on the four corners of the document. I mean, the best we have is the initials HSA, which certainly suggests that was the capacity that your facility wanted. That's the capacity he signed in. And I understand the court may have had some doubts as to the credibility of Mr. Burleson Castillo, but it doesn't seem like there was any specific evidence that he agreed, yes, I am signing knowing that I have this authority and I intend to bind her under that authority. Anyway, we don't need to keep repeating it. I think we understand it, but if there's anything else you want to add, you still have a minute or so.
That's it, Your Honors. Thank you very much.
Very good. Thank you so much. Mr. Booth.
May it please the court, Randy Booth again on behalf of the appellants. Judge Silverman, you hit the nail on the head. Obviously, you were on the panel in Etheridge. You understand the holding there was signing as responsible party excluded her signing as power of attorney. That's the exact same thing we have here. He signed as healthcare surrogate, HCS. It is undisputed and uncontested that those initials mean healthcare surrogate. That's admitted on page 11, lines 4 through 8 of the appendix, and also page 20, lines 19 through 22. So it's not in dispute. That is how he signed. In Etheridge, the evidence of the intent was the capacity. Here, the evidence of his intent in the contract is the capacity that is designated in the contract. It does not matter that he did not type it. To make this abundantly clear, I want you to imagine the contract did say POA instead of HCS. I want you to imagine Mr. Castillo typed that in there before he signed. If the appellants came to you in that hypothetical case where everything else is the same and said, ignore the designation POA, that's irrelevant. Those arguments would be summarily denied. Similarly, if the appellants tried to argue, well, he testified at deposition he didn't mean to sign it that way. He didn't sign it that way. In fact, he had a procedure in place at that time and going back a number of years where he would always confirm that he never signed anything as power of attorney. If the appellants tried to rely on that testimony in that hypothetical, those arguments would also be summarily denied because the contract speaks for itself. It's not ambiguous, it's clear. POA is the capacity he signed in that hypothetical. That is exactly what the appellees are doing here right now. They wrote it, they drafted it, and it is uncontested what it means. They made a choice, and then he signed. Why would they make that choice? We don't get into that. Not in contract law. Contract law does not care why. It cares what does it say. And only if there is an ambiguity do we look behind the contract and ask those questions. Here, there is no ambiguity. If there was, as Judge Morris stated, that ambiguity would have to be construed against the drafters. It would have to be construed against the appellees, but there is no ambiguity. The trial court went outside the four corners of the contract, and in fact, there's no evidence whatsoever that he signed his power of attorney. There's no evidence in the agreement that he was signing his power of attorney. There's not even the suggestion. There's also no testimony or other evidence that he signed his power of attorney. Not even the suggestion. Not even evidence that he intended to sign in more than one capacity. Simply giving the agreements to the people at the nursing home without more is not good enough. Etheridge says it is not about signing while power of attorney. You have to sign as power of attorney. And there is no affirmative opt-out rule in Florida. There is no case that says that. That's one of the concerns I think that Judge Silverman has. Every time somebody signs, they have to write the capacity they're signing in and all the other potential capacities that they're not signing in. That's not the law in Florida. That would be an unworkable rule. That would be a new rule if you were to announce that in this case. And people who are presidents of multiple companies and have representative capacities as well that they occupy would need to carry around, I guess, a laminated card of all the potential capacities so that they could affirmatively opt out of each one every time they signed. That is not what Florida law requires. On the apparent agency topic, y'all know, for apparent agency to be created, the principal has to make a representation. As this court stated in, I believe it's the UATP Management LLC case, an agent cannot create their own authority. If I misquoted the case, I apologize. No, that is, an agent cannot establish her own authority. That's from the UATP Management LLC case versus Barnes. There, the signatory signed a document that had an acknowledgement. That acknowledgement was stronger than this one. It said, I acknowledge that I'm signing with authority. That did not save the arbitration agreement in that case. So in conclusion, the only question is what capacity, did Mr. Castillo sign in his capacity as power of attorney? The clear answer is no. The document shows he signed as healthcare surrogate only. There is no evidence he signed as power of attorney or in any other capacity, and that's the end of the discussion. If there is any ambiguity, it has to be construed, excuse me, against the appellees, and therefore the appellees lose. The trial court committed reversible error in ignoring the clear and unambiguous language and going outside the contract, and in ultimately concluding that Mr. Castillo, as healthcare surrogate, could agree to arbitration. Therefore, the order on appeal must be reversed. Thank you. It looks like you're talking, Judge. I'm
Might be muted.
That's what happens when you forget to turn the mute off. I was just complimenting you both on a very well presented oral argument and good briefing. So thank you very much. You may leave the virtual courtroom. Of course, you're welcome to watch on YouTube if you have any